The next item deals with the process of employment. It's common today that many applications have a box on there and it says, I've been arrested or convicted of a crime. The general feeling is that when that application comes across a corporation or an employer's desk, that it gets immediately eliminated. So the idea of taking that off of the state's application, except in the case of public safety jobs, where that would still remain under this recommendation. The idea is that information about somebody's criminal record, arrest activities, is going to come out, but it would come out later in the process after the candidate for the employment has had a chance to be evaluated. He or she gets a chance to tell their story to the employing agency, and then it doesn't prevent the agency from, in a way, making a decision based on criminal record, but at least the candidate is looked at for things other than maybe just their criminal record. So the recommendation here is to take the box off of the state's application. We had some discussion about how this relates to private employers, but the state here is kind of acting as an example to private employers. This has been done by 10 other states. It's also been done by the city of Atlanta. And so it's a beginning effort around the country to open up the opportunities for employment. Not to hide the criminal record in any way, but it comes later in the process.
At this point in time, I'd like to underscore that the council works by a consensus process. So usually the general rule is that everything has to be unanimous. Previous councils have bent that rule and allowed some dissenting opinions in the council report. But I think that this is limited to just state employment, because I think that this council weighs and understands the importance of the balance of not telling private corporations or employers what to do, and that not telling them what they have a right to know about their potential applicant pool. I think that this is the state saying that we can lead by example, and I think it's important to also underscore that the criminal histories will be a required portion of the employment process, but those would only come out in a face-to-face interview, so that that applicant has the opportunity to explain the circumstances around their arrest and around their conviction. It's also, as Paul mentioned, important to underscore that this recommendation completely exempts all public safety agencies or any other agencies where a criminal background would disqualify you immediately from employment, because that would really just end up being a waste of time. So with that, I'd like to open that up to discussion. Judge or JP?
Would you like a motion?
I think Judge Deal had a comment.
I think we ought to leave some flexibility for the folks that are going to have to try to enact this. I think it probably expands past just law enforcement or public safety. I can envision other areas where you would say, well, we got to have a convicted felon would not be an appropriate person. For instance, a voter registrar probably couldn't be the convicted felon since they can't vote. So I think we just need to leave it wide and put out just the principle of that issue and leave it to somebody else to narrow down the exemptions. But I agree with it in concept.
So I hear that you are recommending broadening that language. Instead of saying applications for public safety positions would be exempt for this requirement, perhaps saying applications for positions where a criminal history would disqualify you from employment immediately would be exempt from this requirement?
Or something to that effect.
Something to that effect. But again, we'll be wordsmithing this again, but that's a good recommendation. Any other further discussion? Sheriff?
Motion.
Do I hear a motion to adopt the recommendation to ban the box on certain state employment?
Second.
All in favor?
Aye.
Opposed?